Okay, thank you for joining us. I'm Tanya, Eiserer, an investigative reporter here at Channel 8. We are back after having lunch and waiting for the Senate to restart proceedings and waiting to see if the defense will call more witnesses or will they rest. Deandra, if you were the defense, what would you do?
Rest.
Why would you rest?
I don't think I would call anyone else and risk them being able to poke some more holes in those witnesses. I don't think the last witness was, unless they have, I was telling you on a break, if they had a witness that was in any of the meetings with the former employees, I guess called the whistleblowers, that had some insight into those meetings, then that would be a helpful witness, but otherwise I don't think I would call anyone else.
But
I think that they probably have the 10 votes they need. I said at the start of this trial that I thought it would be a vote or two either way, and that I thought that he would not be removed. I think that the vote probably still stands where it started at the beginning of the trial. They had 6 to 8 votes on their opening motions. I think they probably have 3 or 4 more who said, well, you know, they haven't completely proven this case. We can't overturn an election, something like that. I think they have the 10. If they have the 10, there's no reason to go on. You might lose one.
And Deandra, we were talking about over the break that the feeling that they needed the prosecution needed to do a better job of telling a narrative, telling a story.
Right. Yeah, they've had moments where I thought they were doing a very good job of that, and other moments where I thought the story was getting a little lost in the cross-examination or the direct examination. But that's one of the reasons I think closing argument is really going to be important in this case, because you've got to pull it all together. You've got to go through each article, and you've got to talk about what witness gave evidence on that, what your evidence, well, also documents and things like that, but what evidence you have to prove up that particular article, because they only have to sustain one. I'm with Bud. I'm going to be surprised if they get the votes to actually impeach him. I would be shocked. But if they do, I really think closing argument could be a big deal. It could really pull together all the reasons, and even if someone just thinks one of those articles was enough, that could make the difference.
And Bud, you thought before we actually got started that they wouldn't even get here.
Right. I thought it would be thrown out on the original motions because the Senate, of course, is overwhelmingly Republican, and not just Republican, but staunchly conservative Republican. Now, their loyalty is to Lieutenant Governor Patrick and what he wants and how he wants things to be done. Lieutenant Governor Patrick, although he's done a very presentable job as a judge in this trial, is politically aligned with Ken Paxton. His donors are the same as Ken Paxton's. He is the chairman of the state campaign for Donald Trump, who called this morning for keeping Ken Paxton in office. And so, I've felt all along that the senators would please Dan Patrick, would do whatever Dan Patrick wants. I was a little surprised that they went ahead with the trial. And there were some senators on that who crossed over, including a couple who seemed to cross over on an integrity reason and say, well, we just can't let this go by. I think that some of those senators, especially if they think the prosecution didn't stitch it together, that the prosecution presented a lot of threads but never stitched them together, never actually showed where Paxton benefited, how anything changed hands, then I think that they'll probably will say, this is a lot of bad stuff, but we need to keep the guy that the voters elected.
Well, and I think we're going to find that out one way or the other probably pretty soon.
Probably tomorrow, maybe. I mean, it just depends on how many witnesses they may still call today, if any, and if we get to closing arguments. I do think it's worth noting that this isn't the end. I mean, Paxton is still under indictment, and that case may start rolling, this fall, allegedly. We'll see. I don't know what's going to happen with it. But he is still under indictment, and there could be investigations we don't know about because they're secret.
Well, there is an FBI investigation.
Right.
There is a grand jury investigation related to all this Nate Paul stuff. We know that because there was already reporting on that, but there's also been testimony about it.
So we don't know where that's going, and I also think that it damages Paxton regardless of what happens, because a lot of the things that were not put out before the election are now out there. I think the electorate will be a lot more, assuming he runs for re-election, if he's not impeached, is going to be a lot more knowledgeable. There's going to be a lot more to work with for people potentially running against him.
I'm going to disagree with that. He's built up a tremendous amount of statewide and national name ID now. He'll say I've been vindicated, and there's no reason for my enemies, the rhinos, to challenge me in court, and this was all a sham, and that I think that he will say all those things and be able to make his cross-country TV tour.
Well, unless he gets convicted and is serving some time during the next election. So.
That would have to be on the federal level, probably.
Yeah.
As we mentioned, the state charge, although there's evidence to uphold it, the state charge on securities is a little shaky because it hasn't been prosecuted before.
But a lot of the reason I think it hasn't been prosecuted has got to do with COVID, and then also there were challenges with the special prosecutors that were brought on board. There's just been a lot of things.
Well, the charge you're referring to that hasn't been prosecuted was the third-degree felony.
Oh, yes,
There's
that
still
one.
2 first degrees.
Yes. There's just, there's a lot of other things going on, but I think that they ultimately will be prosecuted.
And of course, he would continue to serve, if he were, he would continue to serve from, wherever the court sends him on those cases. So he'd continue to be the Attorney General.
If he's convicted, he continues to be the AG?
I believe that's right. I don't know that for sure.
I mean, I guess they could still go back through this process.
Yes.
Assuming, well, we don't, of course, that case we're referring to is the two that he was indicted in 2015 on 2 first-degree felony counts of securities fraud, and then also a failure to register charge, which was a third-degree felony. And that's been batted around between Collin County and Harris County for the last 8 years. It made its way up to the Texas Supreme Court, and the Texas Supreme Court ruled that it would stay in Harris County, and that case, from what we can tell, looks like it's going to proceed.
And that was fairly recently, wasn't it?
Right, that was pretty recent, yeah.
But those remain open articles of impeachment. They were put in abeyance in this trial, but there's 4 of them articles of impeachment. This is something interesting that's going to have to happen at the end of this trial. They're going to have to decide whether to withdraw those articles of impeachment or not, or the House might have to vote again to drop those or to withdraw those articles of impeachment.
Why did they put those in abeyance?
They put those in abeyance because they're in court. And Lieutenant Governor Patrick and Senator Birdwell, the people in the committee, said, let's see what happens on these other articles, and then we can talk about these that are already in court. But of course, he would remain suspended from office because these articles are still in effect if the House does not vote to overturn these articles.
But if he gets convicted of a felony and loses his law license,
he doesn't have to be a lawyer to be AG.
Then I think I'm just walking through the process.
You're thinking like a lawyer and not like a politician.
Of whether he would have to resign or not.
You're thinking like.
Yeah, he doesn't have to be a lawyer. I don't think he doesn't have to be licensed.
This is not a court of law. We're not.
Oh no, it most certainly is not a court of law.
Here, so.
Not a court of law.
Okay, so Jay is going to play for us the clip of Brandon Kamek describing how he ultimately is not going to get paid.
I thought we were going to meet to talk about the contract and what is going on, and but instead, they were like, well, let's not meet here in the office, and they walked me over to a Starbucks outside of the office to have a meeting.
Did you ask why?
No, but it was uncomfortable. It was not professional to me at all. At that meeting, Mr. Webster did all the talking and told me, well, in fact, your contract is not any good anymore. Stop working, don't do anything at all. I asked him, okay, well, what about, paying me?
Do you recall exactly how you put it about whether you were going to get paid? Did you put the amount in there?
I think I ballparked it, and I said, what about my $14,000 invoice? And he's like, well, you're going to have to eat that invoice. I've had to eat $40,000 invoices.
Webster said he had eaten a $40,000.
That sticks out in my mind, sir.
Yeah.
Yes, sir.
Why does that stick out in your mind?
Just because it was offensive. They left the Starbucks and tried to get in the car and drive off. I said, "Excuse me, can I get a ride back to my car?"
So these guys take you to, are you saying that these guys took you over to a Starbucks outside the office, terminated your contract, told you weren't going to get paid, and then drove off? And if you hadn't said, wait, I got my car, they'd have left you in the street?
That's what it looked like.
Royce West is laughing.
Oh my.
If they take you to the Starbucks,
Oh my gosh, don't go to
if
Starbucks.
they take you to the Starbucks, tell you they're not paying you back what they owe you, and ditch you, what do you do?
I don't think you finished the report for Mr. What was his name?
Oh, we're gonna have to. Well,
Kinghorn.
Okay, so Austin. So we're gonna have to just talk about what Austin Kinghorn said. It was technologically kind of too difficult to pair the two up on this. But anyway, basically, Austin Kinghorn, who is the head of legal counsel, is asked about, well, why, he's asked on direct, why doesn't Brandon Kammeck get paid? And he says that he doesn't get paid because he didn't do the report, right? I mean, and if he'd done the report, he gets paid.
He could ask again, and he'd get paid.
So
it's terrible, but it just is it was one of the more interesting parts of these last few days.
How do you match up that testimony?
You don't. I mean, first of all, if you're being told you're going to eat $14,000 invoice, too bad, so sad, and going to be left at a Starbucks, you're not going to turn around and write a report and do more work. And they told him you're not going to get paid and your contract's over. It doesn't. No, I don't buy that story, the Kinghorn story.
I mean, is Kinghorn, I mean, in your mind, is Kinghorn just testifying to what he knows about?
It's very possible. It's very possible that he actually didn't know and picked all this up and was handed to him, and he didn't actually know what the background was.
Because he wasn't involved in the drafting of the contract.
He didn't know.
We know when Kammeck testified, he said Brent Webster was at the Starbucks.
Right.
Ken Paxton and a couple of people that he did not recognize. So we don't know who those other people are, but we have nothing to indicate that it is Austin Kinghorn.
I don't think it was probably Austin
I don't think
Kinghorn.
it was either at this Starbucks meeting, but that seems to be the defense's attempt to explain why Brandon Kammeck didn't get paid.
Well, and I think though if Kinghorn had this conversation with Kammeck on the phone, I'm sure Kammeck would have most likely said, "Hey, I already talked to these guys about this and they told me not to do any more work and they weren't going to pay me." I mean, I think he would have said something back and not just been like, "Okay, nice talking to you." I just don't think that just doesn't ring true.
Do you think that the prosecution should have asked him about that? Because once you've opened the door, I mean, you opened the door to hearsay to begin with, right?
Yeah.
I mean,
Probably should have asked some more questions about that.
Because I mean, once the defense is asked about that conversation, and nobody's claimed hearsay, because that would have been, if they'd have made the objection, that would have been hearsay, right?
Correct.
So they didn't make the objection.
Mm-hmm.
So a potential logical question for them to ask, Aaron Epley to ask, would have been, okay, so did he talk about his meeting with Brent Webster?
Or she could have asked him, Kinghorn, "Hey, what did Paxton tell you about this Kammeck invoice? What conversations did you have with him about paying this, not paying this? I mean, what were you told?" I don't think anybody asked him.
No, they didn't. They didn't. And I don't know if it's because of the timelines that we've got, the timeline situation we've got.
I think that is playing a role.
Because they're trying to keep they're trying to keep the cross examinations pretty tight.
Right. Because they don't know how many witnesses.
Right.
They
only
the
had
defense
2
is going to
hours
call.
left. So.
Yeah, and they're going to try to just hit some key points and sit down, because if they call a whole bunch of witnesses, they just get a little bit of time for cross on each one.
If the defense tries to unfold the vast rhino conspiracy,
and you don't want to be in a situation where you can't ask a question.
Correct. You run out of time, you don't get to do any cross, and so you don't. That's why this is this whole thing is so odd, because in a criminal trial this wouldn't happen. It's just these rules for this particular proceeding, but this isn't the way a criminal trial would
Well, and
proceed.
that's still
in a million ways.
That's still where I think all the legal experts have agreed on this, is one of the failures of the prosecution team has been to better manage their time in the beginning of this trial.
Absolutely. You needed a lot more efficient, direct,
And a better narrative.
And a better narrative, a little bit of a better storytelling. And then apparently I'm getting messages from an attorney in my office that's telling me that if A.G. Paxton is convicted of a felony, he can't run for re-election unless pardoned, and they're looking to see if he would be removed.
Oh, so they're doing some
They're
research.
doing a little research.
Legal research.
They're
We
doing a
got
little
him doing
research.
some work over there.
That's right. He wouldn't be able to run unless he's pardoned.
And apparently there is actually an AG opinion on this
That-
from Paxton.
Right, from
Oh.
Paxton.
So,
Okay,
ironically
well,
enough.
So they're going to go look for it. And we also heard from Justin Gordon, the open records guy. What did you think about his testimony, Deandra?
He came across, I thought, fine. I felt like I would have asked some more questions because who was the guy that directly supervised Justin Gordon, who was one of the whistleblowers that testified?
Mateer?
I think it was Godby.
Okay.
Isn't that Josh? I think it's Godby. I'm thinking out loud. I'm thinking in my head.
Well, there's not a Godby.
Well,
It doesn't sound like Justin Gordon was involved in a lot of these meetings that we heard about the first few days. So I know he had the one meeting with Paxton, which is the only time that's ever happened.
about to be specific,
About this
about a
specific-
DPS request.
Yes, about a DPS request. But it's very likely that Justin Gordon was compartmentalized and didn't know. So not that he's like being a dishonest person or anything, that he is telling you exactly what he knows because he wasn't part of these other meetings that we heard about previously, assuming that those are all true.
He was covering details of, what the DPS did wrong, what this agency, what that agency did wrong, and why this was public. And then we got to the whole kerfuffle over this shouldn't have been public. Are we able to testify about it now? We got into that.
Well, and you were saying, Deandra, that you felt like if they're going to call more witnesses, that you'd want to call witnesses that were present during these meetings to say, no, these whistleblowers, they're all lying. Or
Right,
something to that
or
effect.
I was in the meeting too, and that wasn't the impression I left with, or that's not what I remember happening, or something along those lines. But one thing that I seem to notice, because I did watch all of this because I knew I was going to be here today, so I felt like I needed to watch the whole trial. It seemed like Paxton compartmentalized a lot of things. There were a lot of, like, he'd go to this person and say, hey, I need you to do this. And he'd go to this person, hey, I need you to do this. Hey, and not everyone knew what everyone else was doing until they did, until they all came together and started
had that
comparing
meeting on
and
the
had
eighth
that
floor.
meeting, and then they started realizing what their concerns ultimately were. So if he's doing this compartmentalization, need to know basis type thing, then Justin Gordon his story would fit right in with that.
And same with Austin Kinghorn.
Oh yeah, actually him too. Yeah.
That they know what they know, but
They know,
not,
and
but-
that's all they know.
Well,
Like
and they
yeah.
discussed a lot about this long brief that was posted on the Attorney General's website, and who wrote it and who's responsible for it and what was true and not true in it. And Justin went through all these things that he tried to validate it, and that Austin Kinghorn couldn't validate things that he claimed he could validate. And so we went into this long discussion of basically the long defense of the Attorney General that was posted on the website.
And that was one of the sticking points with the settlement, wasn't it? Was the
Right.
statement.
Well,
They
it
insisted
was
it to be
the s-
removed.
There was a statement that was put out that called them rogue employees, and it was pretty strident. And so one of the terms of the settlement agreement was that statement be taken down. There was a couple other things, and also that Blake Brickman testified yesterday that he wanted that, and then he wanted also that they not appeal that a court of, I think it was the Third Court of Appeals, that had basically said that a public official was subject, an elected public official was subject to the Whistleblower Act, because part of what Paxton had contended was that as an elected official he was not subject to the Whistleblower Act, and
Right.
he said that he wanted to ensure that for future whistleblowers that a public official could not make that
That claim.
Which delayed
would-
the case for.
right, and he said it stopped discovery, which is part of the argument that Paxton's side has made is, well, the voters knew everything, and what Brickman was saying, well, they didn't know everything because discovery got stopped. So
Well, and they didn't. I mean,
I've learned things in this trial.
I've
that I didn't
learned
know.
lots of things in this trial that I didn't know, and I tend to try to keep up, but I didn't know a lot of this. I had many moments where I was like, wow, that's unusual. The whole serving the subpoenas with Kamek.
You mean the
and the
attorney,
win.
the attorney for Nate Paul going?
Nate Paul, yes, that was just a lot. And the whole secret squirrel nature of Kamek being brought on, but he didn't have any way to communicate with the office except through apps and alternative methods of communication. I mean, just all of that was just a little. I didn't know any of that.
But what's wrong with the attorney for Nate Paul going along to do the subpoenas?
Well, there's definitely a conflict of interest. Plus, what is he? If you bring an attorney on to conduct an investigation, which is allegedly what was going on here, then he needs to conduct the investigation, not have an interested attorney on the other side walking hand in hand with you and leading you down
And showing
the
you
path,
how to fill out a
and showing
subpoena.
you how to fill out a subpoena
And providing
all
you
that.
lists of who you should subpoena, and then you subpoena those people. And Kamek acknowledged on the stand that, like, he didn't know, for example, Ray Chester was the attorney for the Mitty Foundation.
Yeah, he just got a list apparently and started issuing subpoenas once he figured out how to do it.
That's
Very unusual.
and I've dealt with people who were special prosecutors or in those types of roles, and that's what Kamek described to me is just very unusual. In terms
The
of
Texas Constitution is silent as to removal. Just FYI, on the AG convicted of a felony.
Interesting.
He'd have to be
Well,
impeached again.
Yeah, and I know there's nothing in the Constitution
Yeah.
about it. The only way you remove someone is through impeachment.
Oh.
So potentially you could
Do
end
this
up
all
hearing it.
again.
And then that gets in question, I mean, double jeopardy, does it apply here, not apply here? This isn't a court, this is under the Constitution. Theoretically, you could bring a lot of this evidence back into court because there's no double jeopardy prohibition in the Constitution, but that would be something that would be argued.
So let's talk about, while we're waiting, let's talk some more about the events of yesterday. We had Drew Wicker. Well, we had the beginning of yesterday when the prosecution announced that they were going to call Laura Olson, and then suddenly that didn't happen. Initially, because they had not met this 24-hour clock. How much of a mistake was that, Deandra, on the part of the prosecution?
I don't understand. I didn't read the rules that they created for this particular hearing
You had to give
in
24-hour
detail.
notice.
But I don't know why they wouldn't have just listed all of their witnesses at the beginning. And that's what happens for the state in a criminal case. You have to tell all the witnesses you might call. So I don't know why they didn't just do that, unless they just made this last-minute decision to call her, which seems kind of far-fetched to me. I mean, or they were trying to do a surprise, or that didn't. And I think it backfired, because had they given notice, proper notice, then maybe she would have ended up on the witness stand. I don't know.
You think there was too much of a lag time there?
Possibly. I mean, I think a lot of things were probably going on yesterday while she was waiting to testify, because she was there. We saw her. There's video playing. She was walking in to get on the witness stand.
I wonder if they had to submit a list of who's going to be called each day.
That's
and
what-
then because they were running short on time, they went ahead and called her, and she wasn't on the list for that day, so they had to wait.
Well, and I think these time constraints have played a big role in a lot of what we're seeing here. But again, early in the trial, we spent an enormous amount of time with Mateer and Banger.
He did.
And
Not very effective time.
no.
No, a lot of it was them telling their story, but just more of their story than probably needed to be told. I don't know how to say that.
Well, and then
That's
you
not
had-
exactly the way I wanted it to come out, but
Well, and then like I had a point along the way, I think it was Tuesday when we had Darren McCarty at the end of the day, and I frankly just, I felt like I'd heard all this before, and it was hard to even pay attention.
We're all thinking that the defense didn't really do as good a job as it could have. There are 31 senators sitting there thinking that too. Now
You mean the
we're
prosecution?
the prosecution, and now we're just in the beginning to hear what the defense has to say, and so we'll hear. Certainly these have been some pretty bureaucratic first couple of witnesses, but we'll see whether the defense has any more big bombastic witnesses to bring forth.
Well, and certainly the defense pretty effectively used the objections to break narrative.
oh yes, and that is, I know you've had attorneys this whole week telling you that's a common thing. Another thing that I don't think anyone's actually mentioned is the fact that there's a difference between doing direct examination on a witness and doing cross-examination on a witness. And you have defense attorneys acting as prosecutors who are accustomed to always doing cross-examination, and they rarely probably do direct examination. And when you have to switch that role, that's when you started getting all the leading objections, because they were in fact leading. There was a lot of leading, which is fine on cross-examination, but it's not okay on direct. And so it can't just be a prosecutor, be a defense attorney, and go back and forth. There's different ways you have to do it, and I think it was a little harder for the defense counsel acting as prosecutors to do
even
direct.
for Erin Epley, when she was challenging Austin Cleghorn on what's his oath, but then she turned and said, "What's my oath again?" Let's see. I know the defense attorney's oath. What's the prosecutor's oath? And so
Right.
she had to remember.
She was a former federal prosecutor. I
Yeah.
did look her up. So
And by the way, I did look up the oath that Austin Kinghorn was supposed to remember is that he swears to represent the state of Texas and to see that justice is done.
how do you think
It
he?
doesn't say anything in there about working for Ken Paxton. So, he seemed to be unclear about who he worked for. He said several times that he worked for Ken Paxton, or that Ken Paxton is who ran the office, and he worked for Ken Paxton, and this is the confusion we have now in a lot of government is that people have a loyalty to the official and not to the people they serve.
You
Or to
have
the-
to swear an oath. I mean, when you get sworn in as a prosecutor, and I'm assuming at the Attorney General office is the same, you literally raise your hand and swear an oath, and you swear to that. There's a statement you have to make as part of being sworn in as a prosecutor.
I mean, presumably you're hired and you're going to stay there through several attorneys general. So it shouldn't matter who the personality is who's holding the office. The defense is making the counter argument. The defense is arguing that because the voters elected Ken Paxton, that Ken Paxton can do whatever he wants, and they're actually taking umbrage at anybody who challenges that. They're taking umbrage at the idea that how dare you challenge something that Ken Paxton said he was elected.
And I don't think it's a political thing to say that we expect our public officials to adhere to certain standards. I just don't view that as political. I think that it is important that we demand accountability regardless of who that public official is. Deandra, we go way back, right? You would say I'm a pretty equal opportunity offender regardless of party, right?
Yeah, there's been
I think I've probably been
You've interviewed me on
unpopular
both
with
parties.
Yes, I mean I am quite. I don't care.
Yeah.
What your political party is. I don't care what your ideology is.
Are you a rhino?
I know.
Look, I just don't. For me, when I'm working on stories, I don't look at it and say, oh, they're this or they're that, therefore I can't do it. It's always about what is right, what is wrong. What is accountability. There was once a Democratic DA in Dallas County that about 10 years ago did a whole bunch of stories on that had to do with misuse of forfeiture funds, and then there was a Republican DA after that who also I did a number of stories about issues with her. So
Some of them with me.
yes, and then we've had judges, and again, so I think that you know, in my job and my role is I don't care about your party. And with Ken Paxton, whether or not what the outcome should be, I take no position on that. But the conduct that's been described here, it's problematic. And I, to a person, I don't hear anybody that understands the way that the criminal justice system operates and the way that the Attorney General's office operates or should operate that says that a lot of what we heard in this trial is normal.
Well, and the way elected
and okay.
the way elected office operates, if if Representative Villalba were here, he would remember this. He could speak to it better than I can, but you know, he would talk about that. You know, when you're elected, you serve a sacred trust.
Right.
You serve in sacred trust, granted by the people, and you serve the people. And that if you serve yourself, then you should no longer be in office.
So there's a live look. You can see there's Chris
Weren't we
Hilton.
supposed to start at 1:30? But they don't even look like. I mean,
No.
I wonder if something's going on.
Well, this is why we have sort of this debate on what time we start the chat back up, is because, or you know, chatting like this, because we never know. They say they'll start back at a certain time, and then they don't. But that sounds like a lot like a trial,
They're
Deandra.
waiting for a ride back from the Starbucks. Or something. The jurors are all.
I will never
sequestered
forget
somewhere.
that.
The Starbucks moment is kind of a classic moment.
So we
for
have,
sure.
we have the Polvos, the Galaxy Cafe, and the Starbucks seem to have all been.
Could take
and
the Paxton
Terry
tour.
Black's barbecue.
Yeah, I could take the Paxton
Yeah, the
tour.
Ken Paxton impeachment tour would be a good adventure. You'd have the Omni elevator. They should have asked him, was that elevator number 1, 2, or 3?
Oh my God.
So that you would just see how many details you remember.
Well, one thing that I don't think you've addressed in the past 7 or 8 days is about the whistleblowers in particular. You know, in this day and age, especially since all of them were attorneys, except the one guy was a police officer, I think.
David Maxwell.
Right.
David Maxwell was a former Texas Ranger.
Hall of Fame.
Very, very, very
Yeah,
well
I remember
respected.
his testimony, but I just, in this day and age especially, if the federal agents come after somebody, they come after everybody. They come after anybody even in any way attached to whatever it is they're investigating. So I know that if I put myself in the position of those folks, and I thought that all these things were going on, I would have been very nervous too. I would have been very concerned, because I think that there's been some question about why did they go to the FBI. I know that was a big questioning that went on in the beginning with Busby, and about why didn't you just go talk to Mr. Paxton about it. Well, you know, when they come after you, they come after everybody, and I think they were all concerned that they didn't want to be co-conspirators.
Well, one of them said that, and I can't remember
That
which
is a
one that was.
legitimate fear.
One of them said that, and
One of them did use that term.
it was one. I can't remember who it was. I don't think it was Banger. It wasn't Mateer because he was first, but it was definitely. Might have been Vassar, but my memory escapes me on which one it was. But yeah, they definitely expressed that concern. One of them expressed that specific, actually said that on the stand, that they were worried that they would be viewed as co-conspirators, and it's and based on all the testimony, it's pretty clear that it wasn't one thing. You know, I think they could have, based on what they've testified to, they could have overlooked the open records thing, the foreclosure order, some of the Mitty Foundation stuff. It really is those grand jury subpoenas.
Oh.
That's the moment when they kind of have because that's when, and talk about what would be the problem to have, as in this case with these grand jury subpoenas that are issued to law enforcement, federal law enforcement, you know, email records and stuff of federal judges, and also to civil opponents of Nate Paul.
Well, I think that what you're doing, if you're involved in that, is you're
Would you please state your
sending
name
up a
for the
flare.
record?
Oh, we've got somebody coming on.
Yes, Your Honor.
Oh, we're
Amy
back on.
Hilton for the Attorney General.
Oh, let's take a look.